Yes.
And because she said that, I just feel a need to read that statement now that I'm under oath.
Yes.
I think that is the one thing.
Yeah.
But the second thing, I want to take my cue from you and follow your advice and respond to what Mr. Siopela allegedly said to Mr. Agrezi. I don't know if you'll permit me to do that.
Yeah, no, that's fine.
Okay.
Yeah.
I want to read my statement, which was prepared and which was filed with the commission. And our statement says the following. I, William Khotso De Wee, hereby declare as follows. Mr. Angelo Agrezi has made several allegations, both in his affidavit and in his evidence to the commission, about what he had been told by Mr. Sisinyi Siopela about money that Mr. Agrezi allegedly handed to Mr. Siopela. According to Mr. Agrezi, my name was mentioned to him by Mr. Siopela. I record at the outset that I deny the truthfulness and correctness of what, according to Mr. Agrezi, Mr. Siopela told him. However, it is correct that, as stated by Mr. Agrezi, I was the Chief Operations Officer of the Department of Justice and Constitutional Development during the period to which he refers. Before responding to the allegations that Mr. Agrezi alleges were made about me, I must record the following. Mr. Agrezi considered during his testimony, as the chair has rightfully indicated, that the allegations he made about me are based entirely on what he had been told by Mr. Siopela. Accordingly, they are hearsay. In the circumstances, it is difficult for me to respond in a meaningful way to these allegations. On the basis of the foregoing, I must record that I'm obviously unable to dispute Mr. Agrezi's evidence in respect of what Mr. Siopela had told him about the money that Mr. Agrezi allegedly handed over to Mr. Siopela. However, I strenuously deny the correctness of the allegations insofar as reference is made to me in the affidavit of Mr. Agrezi's evidence. In particular, I strenuously deny each of the following allegations, direct or implicit, or implications that emerges from Mr. Agrezi's affidavit or evidence. One, that I was aware that Mr. Siopela was receiving money from Mr. Agrezi, and two, that I received money from Mr. Siopela. That I also strenuously deny the following further allegations, direct or implicit, or implications in the evidence of Mr. Agrezi. A, that Mr. Siopela had any basis for allegedly mentioning my name to Mr. Agrezi in connection with money he allegedly received from Mr. Agrezi. B, that I was upset with Mr. Agrezi because he had allegedly been late in getting a delivery of money to Mr. Siopela. Aside from what is set out above, I deny that I was involved in any wrongdoing, either of the type alluded to by Mr. Agrezi or at all. I also draw the attention of the Commission to the fact that Mr. Agrezi's allegations have gravely harmed and damaged my dignity and reputation. And the chair indicated that it's been 2 years since I've been sitting with this problem. I accordingly respectfully aver and submit that in the circumstances, fairness and justice require that. Of course, this is an issue of cross-examination, but I think I wanted to place out the on record. So that's the one part. That's the one part I wanted to deal with. The second part I wanted to deal with. I reject and deny what Mr. Siopela may have allegedly told Mr. Agrezi. I know Mr. Siopela. We were in the student movement together. You might know that back in the 80s, there was an organization called ASASO, which after adopting the Freedom Charter, it metamorphosed into South African National Students Congress. And later it became SASCO. But during the SANSCO period, I think we had a sporting wing called Satisco. So I think it was during around the 90s or so, when I might have met Mr. Siopela. We disconnected. We may have met around 2010 or after 2010. But we have never had a discussion about security or about business related to BOSASA. Frankly, I didn't even know that he was a consultant of BOSASA. I heard from Mr. Agrezi. And Mr. Siopela knows my professional ethics. And he knows my professional ethics because he didn't even try to persuade me about BOSASA, because I think he knew at the outset that I was going to reject that attempt by him. And Chair, I have demonstrated my professional ethics to you personally. By when these allegations came, I took a very expensive choice and a very principled choice that because I am the first secretary of this commission, I decided against all persuasion to say, I am going to step down and I'm going to recuse myself. And I did so because I did not want today that anybody should come here and accuse me of meddling with the investigations. And meddling with the investigations was a possibility because you, of all people, would know that we appointed investigators, we provided them with resources, that I knew their resources, I knew how they traveled and so on. I also worked with you to hire evidence leaders. I would have known him. And I decided way back in August 2019 that I am going to recuse myself from the commission because I don't want anybody to say the commission meddled with this thing. We try to cover ourselves. Unfortunately, the mistake that I made, because as you know, I thought this matter will be dealt with within 2019. It went longer than I had thought. And now we are here in 2021. I'm still faced with these allegations. And they've been very painful, I must tell you. They've been painful to me personally. They've been painful to my family. They've been painful to my children. Even some friends, distance from themselves from me. I was I was socially isolated because of this allegation. And in life, people don't even wait for proof. The people don't even want facts because of these allegations, Chair. So they've been very, very painful. But maybe I will mention the others as closing remarks. But I wanted to put that on record, Chair.
Yeah. Okay. All right. Okay, Ms. September, you may start.
Thank you, Chair. Sir, may I call you Dr. De Wee, Mr. De Wee? Which would you prefer?
I'm easy either way.
Okay, Dr. De Wee, it's easy. So, since none of the versions that you provided to the Commission are in fact under oath, apart from that one statement which you've read now, it would be of great assistance to this Commission just for you to verify the statements that you have in fact provided to us. If I could ask you, before you should be a bundle titled BOSASA Bundle 5.
Yes.
Is that the bundle we are using today, Ms. September?
Yes.
Yes, okay. You want us to go to what page?
In particular, there is a tab marked T35, which is at page 3.
Yeah, if you give me the page number, that's much easier for me than the tabs.
302.
302.
And Dr. De Wee, just to confirm, the page numbers we refer to is that which appears on the top left-hand corner.
Yes,
of the page.
302, yeah.
If I can ask you now then to turn to page 313.
Yes, ma'am.
Do you recognize this document to be a statement that you two provided?
Yes, I recognize it.
Can I ask you to turn over the page to page 314?
314, yes.
Is that your signature which appears above the date of 23 January 2019?
That's correct, Advocate September.
And you confirm that the facts that's contained in this document are in fact true and correct to the best of your knowledge and belief, unless stated so otherwise?
Yes, I do.
Thank you. Can I then ask you to turn to page 320?
Yes, ma'am.
Do you confirm, sir, that this is also a statement that you've provided to the Commission?
Sorry,
Yes.
what page is that, Ms. September?
320.
Oh, okay, I've got it, yes.
Thank you, Chair. Dr. De Wee, do you confirm that this too is a statement that you provided in answer to Mr. Agriti's answering affidavit in relation to...
Yes, that's correct. Except that I don't know if I'll be allowed. There's a point in Mr. Agriti's affidavit I wanted to deal with. I don't know if I could be allowed.
Yes, you will be. You can either make a note of it and deal with it at some stage, or if you don't want to forget it, you want to deal with it.
Okay, no, it's fine. I know where it is. At the opportune moment, I'll deal with it, yeah.
Okay, all right. Okay, continue, Ms. September.
Thank you. So at page 320, you confirm that that is in fact your signature above the date of 15.
Yeah, that's correct. That's correct.
Thank you so much. And that what is contained in here is in fact true and correct to the best of your knowledge and belief, unless stated so otherwise.
That's correct, Advocate.
And then the last document which you provided to the Commission is at page 398.
Yes, I recognize the document. Yes, that's right.
And you confirm that this is in fact your response, which is not signed at all, but continues until page 417.
It is my response. I can recognize it. Safe to say that with the passage of time and having looked at it, there may be certain things I just want to, I don't know if the concept is ameliorate or amplify.
Yes.
But it is my statement.
Okay.
And then just for the record, is it correct that this particular response attached various annexures which you provided to the Commission?
That's correct.
And because of the very special numbering that you've allocated the annexures, for the record, it's marked annexures A, B, C, D,
yes,
then EF, followed by GH, which is one annexure, followed by IJ, which is another annexure,
yes,
L, which is a further annexure, and M and N.
Just be slow, Advocate September. I'm a little bit slower than your pace. Just hang on, I'll be with you. I'm just going through my file. I'll be with you because there are other things I've added here.
Ms. September, the annexures to Dr. De Wee's response, all the documents that come after her response up to the end of the file.
Yes, Jay.
So it's annexures A up to N, is that right?
Yes, Chair. There's a different style of annexure naming that this was identified. So just for record purposes, but certainly it's all annexures from pages 115 right through until pages 333, some of which has been redacted to not deal with the issue which is not to be dealt with today.
Okay, all right.
Yeah.
Okay.
So then lastly, Dr. De Wee, do you confirm then that subject to any changes that you may make during these proceedings, what is contained in your response, which are answers to questions posed to you by the Commission's investigators, are in fact true and correct?
Yes, they are true and correct, but I've already indicated that when I look at them, there must be some small amplification that I can do during the course of this meeting. Just to clarify certain things, yeah.
Thank you. Maybe then start with looking into the allegations that are in fact against you as alleged by Mr. Agrizi.
Yeah.
For that purpose, we're going to look at the time period of 2008-2009 to 2016, and in particular, the contracts that were awarded to the Department of Justice and Constitutional Development during that period.
Yeah. Yeah, I'm happy with that, and I'm going to try my best to answer all your questions. But Chairperson, there's a small point I had wanted to make, with your permission.
Yes.
I just wanted to make a very, very small point. If I could, if you can turn to, let me just go to this page. There's a small point I just wanted to make. I will tell you what page is it. If you can turn to page 331 of the file.
Yes, that's a transcript.
Yeah, it's a transcript.
Yeah.
And then you look at paragraph 20.
That is line 20, marginal line 20. Yeah.
Yes, yes.
Yeah.
You see there the talk is of 2013, 2014.
Mm-hmm.
Mr. Agrizi said his allegations related to 2013, 2014.
Where is that? I can't see that.
On line 20.
On line 20, yeah.
On line 20.
That was probably about 2003, 2004, if I remember correctly. Then he says
2013,
2014.
Yeah.
Mm.
If you go to if you go to just give me a moment. If you go to page 338.
338.
Yes. Paragraph 39.1.
Yeah.
You see there's a line there that says, during approximately 2013, Sondolo IT Limited was awarded the contract of secure systems at various courts across the country with the Department of Justice and Constitutional Development. In other ways, the point I'm trying to make to you is that the previous page we saw and this page are basically saying the same thing.
In terms
That's
of
the point I'm making. In terms of 2013.
Yeah.
Now, and is there throughout the document.
Yes.
Now, the consequence of that is that you then issued a media statement on the 18th of January. With your permission, I would like to read that media statement.
Yes.
And what it says.
Yes, read it.
The media statement reads as follows. In his affidavit submitted to the commission, Mr. Angelo Agrizi, the former CEO of BOSASA and the witness currently giving evidence before the commission, has, among others, stated that he was told that the secretary of the commission, Dr. Khotso De Wee, was one of the senior officials of the Department of Justice and Constitutional Development who were paid bribes by BOSASA in regard to a tender of 2013 for the establishment of a security system in various courts throughout the country. Mr. Agrizi states that Dr. De Wee was the COO of the department at the time, which is correct, which I have not denied. However, Mr. Agrizi also states that he has no other information to confirm the correctness of this report. And then you say, after I had become aware of the above statement in Mr. Agrizi's affidavit, I brought it to Dr. De Wee's attention, Dr. De Wee confirmed that he was the CEO of the Department of Justice and Constitutional Development in 2013. However, he has informed me that he was never at any stage paid any money by BOSASA or by anybody from BOSASA, including the person mentioned in Mr. Agrizi's affidavit. And it's a point I'm repeating 2 years later. Through its investigators, the commission is investigating the allegation against Dr. De Wee. In the light of this and the seriousness of the allegation against him, Dr. De Wee has offered not to report for duty, in effect to take special leave pending the outcome of the investigation of the allegation against him. And you say, I have accepted Dr. De Wee's offer. Accordingly, pending the outcome of the investigation of the allegation against him, Dr. De Wee will stay away from work. It is envisaged that this will be with effect from Tuesday, the 22nd of January 2019, next week, as it's going to be necessary for me to appoint somebody as acting secretary of the commission who will perform the duties of secretary of the commission during Dr. De Wee's absence. The point I'm making, is that what has been transmitted to the public for a period of 2 years is the idea that I was paid on the basis of a 2013 contract. I'm saying to you, and I'm going to speak to Advocate September about 2008 and all other issues that she wants to raise. I'm saying to you, I want you to record a note that whilst Mr. Agrizi has told the public about 2012-2013, I've never been given documents about 2012-2013. And if they are there, I want to see them. I would just want to make that point. In other words, 2 years has lapsed. You know, Chair, I had wanted to raise this issue in the end, but I might as well say it now.
Yeah.
I've kept away from you. You are probably aware.
You can't keep away from me, and I'm not aware, Dr. De Wee. If you are keeping away from me, I must be aware of it. Yeah.
And that's because I had wanted this thing to be dealt with properly and be dealt with and so on. But now, you know, I buried my sisters in August last year. In August 2020. And my great misfortune was that there were 3 of us left at home, me and my 2 sisters. Unfortunately, in August last year, they passed away at the same time. They passed away within a week of each other. I am not asking for sympathy, but I'm saying the way these things have happened, my own sisters thought I had stolen 15 million from government. And they don't understand how come I can come to Gauteng and just steal 15 million. Now, this thing has taken so long. This 2013 has never arisen. I've never seen memos. I've never been engaged on it. Now, what is painful to me as a person, my dear sisters who were worried about this, who thought I had stolen 15 million of government money, they passed away without getting a satisfactory explanation about this big theft I should have committed. So I am saying, because of the way this thing was done, 2013 was raised. 2013 is now in your statement as chair. I would have expected the investigators and the evidence leaders to stress about 2013. Now, that doesn't mean I'm not prepared to answer. I want to deal with all questions that I can possibly get. I'm not running away from it. But I'm saying the public perception there was about 2013 that Mr. Angelo Agrizi mentioned repeatedly throughout his survey. And there have never been any document to this date. I rest my case, Chair.
Yeah. Well, what I can say to you, Dr. De Wee, is it was unfortunate that the investigation took as long as it did. And Ms. September will deal with matters and put questions to you and deal with matters as she goes along. Obviously, when these things happened, I certainly thought it shouldn't take more than 3 months. And it ended up taking too long. And during that period, sometimes I would be asking, why is it taking so long? You know, so, but understand. Ms. September, continue.
Thank you, Chair. Aligned to the work of the Commission to interrogate the allegations against you, sir, Mr. Agrizi's evidence deals with the time period of 2008 to 2016. Is it correct that you were appointed as the Chief Operations Officer for the Department of Justice and Constitutional Development from 1 April 2005 until 30 June 2015?
Dr. De Wee, can you hear? It's like he's frozen. Dr. De Wee? No, I think he's frozen. Mr. Matime, you can hear me.
Yes, I can hear you, Chairperson. Can I maybe send the IT guy from my office to go and attend to it? Maybe?
Yes, that's fine.
Yeah.
Please do that. Yeah.
Thank you.
Okay. I wonder whether we should just take the tea break while the IT guy attends to that, so that because we don't know, we might wait for 5 minutes, 10 minutes. I think let's take the tea break, and then when I come back, I'm sure everything will be fine.
Thank you, Chairperson.
We adjourn.
Thank you.
Recording stopped.
The line got cut, Dr. O. Ask him to rejoin them, Mr. Matime. mute button. Then you'll show yourself there. Thank you. Can you quickly log off, Dr. De Wee, and then log on again quickly?
Okay.
That's the best way to just quickly log off, leave the session, and then come back on quickly. Now I can see you. Now I can just adjust. There we go. Thank you.
Oh, sure. Okay. So let me take off the. You might think I'm now in disguise, Reverend. So I'd rather take it off. You know, you don't hide yourself from Muruti.
Bless you, my child.
Okay.
Okay. Thank you so much.
Okay,
Ms. September, are you there?
Yes, I am.
All right. Thank you. Ms. Tematimi, are you there?
Yeah, I'm here, Reverend. Thank you.
Thank you so kindly. Roshan, we are in your hands. You let us know when the DCJ is processing.
Will do, Rev.
Thank you.
Good morning. We will resume today's proceedings. Please unmute.
Recording in progress.
Okay, let's resume. I understand the technical problem has been sorted out.
Yes, it has been sorted out, Chairperson. Thank you.
Thank you very much. Okay, Ms. September, you may proceed. You had asked a certain question, which I assume Dr. De Wee probably didn't hear. Do you want to put the question again?
Thank you. Before I repeat that question, might I be permitted to request that the documents used for today's proceedings, which is pages 302 to pages 636, be accepted as Exhibit T35 of BOSASA Bundle 05, please?
Well, each one would have to be dealt with on its own. So I guess as you get to each one, request that it be admitted, and then we take it from there. You said they start from page?
The exhibit bundle starts at page 303. Until page 636.
Yeah, we won't have a blanket thing. We'll just have to, 303 is an index. So we can't make an index that is an exhibit. So as you get to each document, you can then request that it be admitted, and we'll allocate it its number. Okay. All right.
To repeat the question I asked earlier, sir. Mr. De Wee, is it correct that you were appointed as the Chief Operations Officer for the Department of Justice and Constitutional Development from 1 April 2005 until 30 June 2015?
That is correct, Advocate September.
Can you please clarify to the chair what were your responsibilities and deliverables as Chief Operations Officer?
Well, first and foremost, I came to be appointed the Chief Operations Officer of the Department of Justice and Constitutional Development, as it was known as at the time, from my position as the Director General of the Free State. At that particular time, the Chief Operations Officer was a totally new position in government. And there was a motivation for the creation of that particular post. And without going into great detail, the motivation was as follows.
Don't go into the motivation, Dr. De Wee. Just deal with what the functions were for the position.
Okay, well, the function was basically to support
duties, in other words, the responsibilities.
Yes, to support the Director General in his administrative duties. But in my particular case, I was mandated to create new chief directorates, or at least I proposed to create new chief directorates. The chief directorates at the time, I think one was called Program Support and Administration. It was a chief directorate we used to support the regional offices at the time. And subsequent to that, it dealt with all service delivery issues and complaints mechanisms and donor funding and so on and so forth. The second chief directorate that we did, that we focused on, was strategy, development, monitoring, and evaluation. In other words, I was given the responsibility to develop the strategy of the department, monitor it, evaluate it, and then report to the director general, to the minister, and so on and so on. So that was the second chief directorate that I developed. The third chief directorate that I created was a chief directorate called Post-Truth Post-Truth and Reconciliation Commission Unit. The essence of it, when I came in 2005 into the Department of Justice, the minister at the time felt that we can implement it. And then I later proposed the creation of a chief directorate. And that work, I think, is still continuing. In case you don't know, Chair, subsequent to that, I've been working on a book in the last 2 years. I've just published a book in which I'm sharing my experiences of implementing the recommendations of the Truth and Reconciliation Commission in government. So at least I've been working on recording that.
Okay, that's very good.
Yeah.
Yes.
But then fourthly, we then created, I think if I remember well, there was a directorate for security that used to be in a branch called Court Services. And then I think we amalgamated it with Risk Management Unit and created a chief directorate called Security and Risk Management. So I had 4 chief directorates with me. But given the challenges of the department at the time, you'll notice that I also did a number of things whilst I was COO. I used to act as a head of Justice College at some point. At some point, I acted as I think during the process of creating the Office of the Chief Justice, I was then given the responsibility to act as the head of the Office of the Chief Justice until I think the post is called Secretary General. Until a new post of Secretary General was. So those are really a number of things that I did during my time back then.
So specific to the functions relating to security and risk management, is it correct that, and please correct me if I'm wrong, but is it correct that you would have had oversight, management, and control in relation to all aspects concerning the operations within the security and risk management cluster of the department?
Yes, we had a chief directorate. We had a chief directorate for security and risk management. And there were several people over the period who acted or who were appointed as chief directors. And those people were reporting to me as a COO at the time.
And then specific to your involvement in any procurement of service matters, what role did you play?
There were 2 instances that I remember in which I played a role. I think there were I was not intimately involved with procurement because procurement was largely driven from the Office of the Chief Financial Officer. But there were instances where I was requested, and not because I particularly had an expertise, but maybe because of my seniority in the department, I was requested on 1 or 2 occasions, probably 2, if you look at the forensic report, to chair the evaluation committee. And then obviously once that is done, we will make recommendations to the departmental bid adjudication committee.
Okay. So before we turn to deal with the contracts in issue during the period alleged by Mr. Agrizzi, will you agree with the general proposition that the life cycle of a public tender would include the procurement of the service through the award of the tender, firstly? Would you agree with that as a general proposition?
Yes, generally, to remember, supply chain management ordinarily is regulated by the Public Finance Management Act. And the key provisions of the Public Finance Management Act is to ensure that whenever we procure, we are guided by specific regulations. And some of the regulations require us to test the market. And the essence of testing the market is to advertise. Once the advertisement has been issued, the people in supply chain management will do something called pre-qualification. They will check tax compliance. They will check the extent to which all the people who submitted tenders comply with the requirements of the advert. And I think from there, I think before then, in fact, there will probably be a process of appointing bid evaluation committees who will draft the specifications before they are even advertised. And then when the advert has run its course and the pre-qualification has been done, then the supply chain management unit would come to the bid evaluation committee, which ordinarily, I think in most cases, would be appointed by the Director General. There will be letters issued by the Director General to appoint the bid evaluation committee. And then documents would come and then we will assess, and then because we are a bid evaluation committee, we will then pass on to DBAC.
And
in other words, the point I'm making to you, and maybe this is a point that would arise as we go along, you and I, Advocate September. In procurement, there's a relationship between bid evaluation committee and bid adjudication committee. The bid evaluation committee will do just technical work to check compliance and so on, and maybe see in terms of points who's likely to be the next candidate, the best bidder, and then submit a recommendation to the departmental bid adjudication committee, will then make a decision. But the appointment is not made by the departmental bid adjudication committee. The departmental bid adjudication committee will oversee and make an assessment of the work done by the departmental bid evaluation committee. And once it is satisfied with the recommendation, it will then submit as a DBAC a recommendation to the accounting officer, to the Director General, to approve or not approve. So there will be instances where the bid evaluation, the bid adjudication committee would agree with the bid evaluation committee, and in cases where they don't agree, they will send matters back to the bid evaluation committee until they are satisfied with the process, until there's a point where a Director General or accounting officer would apply. But of course, I must also say, there were instances where I was asked to act as a Director General, in which case all these processes would then come to me. And if I'm satisfied with the matters that have been put before me, I would then consider approving or not approving.
Your comprehensive answer certainly presents that you were very aware of exactly how the procurement process worked within the department. Is that correct?
I'm not necessarily an expert, but yeah, there is some degree of awareness because of my public service experience.
Okay, but you certainly understood exactly the different stages within the process from the time of throughout the procurement process, rather.
Yeah, I would say that's correct.
Thank you. And so if one were to accept that the first part of the life cycle of the tender was the procurement of the service, would you agree that the next part would be the implementation of the work project, where the scope of the service may change or not, depending on how things unfold? Would you agree with that? General proposition.
Sorry, can you repeat the proposition? I'm not sure I quite understand you.
No problem. So the first part which you accept is that the life cycle of a public tender commences with the procurement of the service through the award of the tender.
That's correct, yeah.
Following that, the next part to that life cycle would be the implementation of the work project.
Yes, I would agree. I mean, once procurement has been done and we went through relevant. Advocate September, are you speaking? Sorry. I don't want to speak out of 10. My apology, Chairperson, for that.
Sorry.
Okay, yeah, wait for her to finish. Let's go back. Ms. September.
So you accept, sir, that the next part of the cycle would be implementation of the project, which would either include a change in the scope of the project or not?
Yeah, what I agree to is that, yes, there will be procurement. And once that it went through all the stages that I have mentioned, and the bidder has been approved by the accounting officer, and a letter of appointment has been issued. After that, there's implementation of the project. But you mentioned something that I want to react to. You mentioned change of scope. Change of scope doesn't happen automatically. There are public service regulations that regulate how a change of scope happens. Because when a bidder is appointed, that bidder is appointed in terms of the requirements of the tender that was issued, and the requirements of the tender issue defines the scope. If there is a need for that scope to be exceeded, there's a particular process that must be followed to ratify that. Are you with me? In other words, I'm saying to you, once a bidder has been appointed, a bidder is not at liberty, or officials are not at liberty to change the scope as they wish. Because appointing a bidder follows a process. Changing a scope also must follow a particular process.
And what process is that, sir?
I think ordinarily, if there's a need for a change of scope, there might be a need to go back to the DBAC to seek approval and for the recommendation to be given to the DG to approve.
Thank you for clarifying that. The last part of the cycle, the life cycle, would then be, once implementation has taken place, payment for the services needs to be made. Is that correct?
I would agree with that, yeah.
Okay. Now, when we
but I must also just indicate to you that I guess experience may differ from place to place. But ordinarily, if we appoint a service provider for a period of 2 or 3 years, normally there is an arrangement of monthly payment to the service provider. In other words, we don't wait for the service provider to finish work first for 3 years, and only after that 3 years we pay. There are arrangements that are made. And simply because, take security, for example. If we contract a security company to provide security for the courts, obviously those people will have to get equipment, they'll have to hire guards, and those guards, because they'll be doing work over a month, they can't wait for 3 years. They have to be paid on a monthly basis so that they can, like you and I, take care of their needs.
But in line with what you're saying, sir, you would though agree that final payment for services rendered would only be done once all services have been delivered. Is that correct?
It will be done once services have been delivered in terms of the agreement. It depends what the agreement say, in terms of the agreement.
Yes, I guess that everything has got to go according to agreement. And if the agreement is a service provider will be paid when they have completed the job, that's what must happen. If the agreement says, although the job will take 3 years, the service provider may submit invoices for work already done during that period, whether on a monthly basis or whatever intervals. If the department has agreed to that, then payment must happen in accordance with that. That's the point you are making.
Yes, that's correct, Chairperson.
Yeah.
Sir, thank you, Chair. Sir, can I ask you to turn to page 478, please, of the bundle, which is a document that you provided to the Commission.
478.
Yes.
Ms. September, I want to mention that I don't expect us to take more than an hour and a half. But if you think that there would be justification to go beyond that, you would tell me. So I just want you to have an idea what my expectation is in terms of this sitting. But if you think there's justification to go beyond that, you'll let me know and we'll take it from there. But I don't think we should be taking more than that.
As it pleases, Chair. Only certain aspects of the transactions that need to be queried with the witness for his answer.
Yeah,
okay.
No, that's fine. Let's continue.
So at page 478, you will see that there appears to be a service level agreement concluded between the Government of the Republic of South Africa through the Department of Justice and Constitutional Development and Sondolo IT Pty Ltd. Is that correct?
That's correct, Madam September.
Can I then ask you to turn to page 484, please?
Page 484.
Before you do that, September, tell us what year that contract, that agreement was and what it was for and so on.
Yes, I was about to do so. At page 503 appears the signatures of this agreement, which is dated 15 July 2009. If we go back to the page of 484, it describes what this contract entails. And in particular, paragraph 2.1 reads that it concerns the principal, who is government, requires the supply, delivery, installation, commissioning, support, and maintenance of a comprehensive CCTV alarm and access control system at various nominated court buildings, which is termed the facilities.
Yeah.
Clarifies further at paragraph clause 2.2 that the bid was awarded to the contractor, in this instance being Sondolo IT, in the amount of 601,863,308.80 cents in respect of 127 facilities which are court buildings. It goes further to state.
Okay, I'm sorry. Let's start by placing on record that it's an agreement that was signed both by or on behalf of the Government of the Republic through the Department of Justice and Constitutional Development and by Sondolo IT Limited, Pty Limited on 15 July 2009. And you say from what you have read, it was an agreement between the two parties for the provision of CCTV,
alarm and access control system at 127 court facilities.
Yeah, okay, all right. I just wanted to make sure that as we proceed, we know when it was, the agreement, when it was signed, what it is about, and who the parties are. That's been taken care of. Now you can go ahead.
Thank you, Chair. With a contract value of 601 million rand. Dr. De Wee, during your term as Chief Operations Officer, at what value is it compulsory to proceed on open tenders?
Well, maybe before you do that, Ms. September, Dr. De Wee, at page 503, that's the page that has got signatures there. Is any of those signatures your signature?
503. No, Chair, it's not.
Yes.
My recollection is that the one signature, Chair, to what extent are we allowed to mention names? Because I know there's a sensitivity around people's names. I mean, to start with, there's no signature of mine here.
Yeah,
I think I have an idea. I have an idea whose signature it is, but to what extent am I allowed to?
You can mention whose signature the one is that is there for on behalf of the government of the Republic through the Department of Justice. You can mention if you know it.
Just a short history of this, just very brief history.
Yeah.
After the tender has been issued, I think the then Director General requested that Mr. Vuso Shabalala should be assigned the responsibility of signing this agreement on behalf of the department. So this signature belongs to Mr. Vuso Shabalala, who at the time, if my recollection serves me well, was the Deputy Director General for Corporate Services.
Okay.
And he was mandated, I think he was mandated, and following, I think the then Director General then appointed a certain Advocate Hussein to just check the agreement and make sure that it's satisfied. And once Advocate Hussein gave an indication to the then Director General that he's happy with the service, I think there was a bit of negotiations with Public Works and other, because there was some committee that was set up to engage various stakeholders who were going to be affected by this. Once that process had run its course, by Advocate Hussein doing the negotiations, I think the then Director General then mandated Mr. Shabalala to sign on behalf of the government, of the department.
Okay, no, that's fine. Okay,
I can assist you in turning to page 474 of the bundle, where on the 1st of September 2009, the DDG for Corporate Services was delegated to sign this particular SLA. It aligns also with the recordal of the designation on page 478, which is the DDG for Corporate Services representing government.
Yes, okay, all right.
As signatory, so authorized.
Okay, go ahead.
Dr. De Wee, at what value of contract is it compulsory for bids to go onto an open tender?
You know, my recollection, and I still need to check the circumstances. I recall there's a regulation that says any tender above 500,000 must go on open tender. I seem to remember something in that order.
So what was your role and involvement in this particular tender process?
I think I was in the bid evaluation committee. Bid evaluation committee was really between supply chain management, which is supposed to do pre-qualification. Once they've done with pre-qualification, they would then bring it to bid evaluation committee to check the technical specifications. Once we are done, we'll hand it over to the departmental education committee.
Were you a normal member, or did you hold a position of authority in the department?
I was a COO of the department, so I might have been the chairperson of the bid evaluation committee. But the point I'm making is that the bid evaluation committee, and you remember initially I differentiated between the roles of the bid evaluation committee, the bid adjudication committee, and the accounting officer. You remember I traversed that route earlier on. So we, as a bid evaluation, we're just checking the technical specifications and then hand it over to the bid departmental adjudication committee to decide whether they want to recommend it to the accounting officer or not.
Would it have been the bid evaluation committee or the adjudication committee that would award points?
I think the point might be I think sometimes it could be both, Chair. It could be bid
Yeah.
evaluation committee and then maybe check with bid adjudication committee. But the people who would have authority to recommend to the accounting officer will be the bid adjudication committee.
Yeah.
Yeah.
Okay, all right. I just want to cover something so that I don't forget. I wanted to cover it much earlier. That goes back to the fact that Mr. Agrizi said concerning you, he said was what Mr. Siopela told him. I just want the public to know that the commission did try and get information and affidavits from various BOSASA officials, including Mr. Siopela, and they did not cooperate, and they did not finish any affidavits, so including Mr. Siopela. Of course, what the commission did at a certain stage towards the end of, I think in 2020, early in 2020, it began to focus in terms of its investigation on what I call the public protector issues. Now, the public protector issues are those issues that the public protector had identified in her report, The State of Capture, as issues that the commission should investigate. Those issues really revolved around tenders and contracts and influence of the Gupta family on government. So those public protector issues would exclude BOSASA matters. So what I'm saying is that there were attempts to obtain affidavits from BOSASA officials, but at a certain stage, the commission had to focus on the public protector issues, because what had happened was that when the terms of reference of the commission were crafted, they were widened. The issues were widened much more than the issues that had been identified by the public protector. The scope of the investigation of the commission in terms of the terms of reference as opposed to the public protector issues would have involved investigating allegations of corruption even in the municipalities. So it became clear that there was no way the commission would canvass all issues falling under its terms of reference. And and then it focused on the public protector issues, but we undertook to try and complete any issues that fell outside of the public protector issues, but within the terms of reference of the commission that we had started. So I thought it's important to mention that so that the public does know that the commission did try to obtain evidence from people such as Mr. Siopela, but there was no cooperation coming from him and other BOSASA officials other than those who came to assist the commission after or around the time that Mr. Agrizi testified or after. Okay, all right. I just wanted to place that on record. Okay, Ms. September, continue.
Thank you, Chair.
Chair, before Ms. September continues.
Yes.
Earlier on, she asked me about who allocates the points.
Yes.
You remember? and I obviously have no recollection.
Yeah.
But can I draw your attention to a memo labeled 466?
Is it at page 466?
466, yeah.
Yes.
If you look at that memo, the memo says in 2.1, you see it's a memo to the Departmental Bid Adjudication Committee. And it's a memo that came from I think from the Bid Evaluation Committee at the time, and from my office. It says the following. If you look at 2.1, it says the bid was issued on 29 February 2008 and closed on 20 March 2008. In other words, the point that is made there, it says that the market was tested. I have no recollection whether was this by a closed tender or open tender, but certainly it makes the point that the market was tested as provided for by the Public Finance Management Act. Secondly, it says pre-qualification was done and one bidder was recommended. I had explained earlier, Chairperson, that normally the Office of Supply Chain Management will be the one doing pre-qualification, checking all the technical requirements and so on. And I think from them, they indicated one bidder, right? It then in paragraph 2.3, it makes the point that the evaluation committee evaluated bid documents on the 5th June 2008, and it specifically says the criterion used for this phase was the price. So I would imagine we compared prices right across the board. The tender was 90-10. I would imagine 90 for price, 10 for functionality. And it says the committee came to the conclusion that the recommended bidder's price is fair and market related. And then on that basis, the evaluation committee members, including myself, we then recommended to the bid adjudication committee, who then decided whether they agree with our recommendation or not. And if they agreed, then they would take it further to the accounting office. I just thought, given Ms. September's point earlier, I should draw that to your attention.
Yeah, no, that's fine. I don't know why anybody decided that even a memo like this, we mustn't see the names of the other bid evaluation committee members.
Well, Chair, if you don't mind me responding.
Yes.
This document, it comes from your office.
Yeah, no,
it was given to us by your office. So
no,
I don't want you to get an impression that remember the point that is made here. The point that is being made here is that we've been manipulating the process so that we can get bribes. So I'm
trying. No. I have no problem with that, whether it was from within the commission or outside. I just don't know why the names of people serving in an evaluation committee of a government department needed to be hidden.
I don't know.
Yeah, I mean, even I see in the memo, well, if people were involved in this memo, I don't see why their names needed to be seen.
Chair,
okay, let's continue.
Thank you, Chair. Chair, but I do confirm that the redactions were in fact done by the commission itself in preparation.
Yes. Yeah, I mean, I think people might just be overcautious for nothing. I mean, you serve in a public body. If you were part of the committee, you were part of the committee. It doesn't necessarily mean a particular allegation is being made against you. You are part of the committee. It's a public body. You got paid for doing that job, and the public, insofar as it simply gets to know you are part of the committee, there's nothing wrong with that. Yes, okay, let's continue.
Dr. De Wee, in line with what you've drawn attention to, and that is the recommendation of this bid evaluation committee of which you were chair, it is understood that through you, legal opinions were sought before this recommendation was made. Do you recall the opinions that were obtained and why?
I'm very happy that Advocate September has raised with this question. Chair, with your permission, can you allow me to deal with this thing in full? I just want to respond to this in full, as Advocate September is
well, don't respond to it in full as yet, because she may be having other questions where you will be able to give your other answers. But if at the end there is anything that you think hasn't been canvassed, I'll give you a chance to deal with it. So you can make notes as we go along so that you don't forget.
Chairperson, with your permission, there's an important and specific reason why I would like to this matter in full.
Yes,
and it's because of your investigators. If I have to be frank with you, I just want to deal with it because there are things that I want to show you that they did that prompt me to deal with this thing in full.
Hang on, Dr. De Wee. I'm telling you that let her ask questions as she goes along. You may get a chance as you answer those questions to deal with issues. And if she, in her answers, her questions, she hasn't touched what you want to deal with, I'll give you a chance to deal with it. I'm saying make a note so that you don't forget.
Yeah, let me assist you. I'm here to assist you.
You are not assisting me now.
Oh, okay.
You are spending time that we should be spending on the questions. I'm saying she knows what she wants to ask you. As she asks you questions, answer the questions she's asking you. But there may be issues that she might not ask. Then make a note. I will give you a chance later on to say, in regard to this topic, I didn't get a chance to deal with everything because she didn't ask certain things. Now I would like to take this chance to say what I didn't say. So I want you to make a note so that you don't forget. Is that all right?
In that context, let me respond to her question.
Yes, but I don't want you to forget whatever it is you wanted to say when you said you wanted to respond in full. So please make a note. You'll get a chance to do it.
I guess my problem is that I waited for 2 years to deal with these issues.
Okay.
as you would appreciate.
Yeah, okay.
Ms. September here has been confused by the investigators.
Mm-hmm.
And I will explain why I argue that she has been confused by the investigators.
Yeah.
She's correct. There was a legal opinion that was requested.
Mm-hmm.
Okay. And her confusion arises from the manner in which the investigators dealt with this matter.
Mm-hmm.
Because the investigators, and I can show you by way of documents, they confused and conflated two processes.
Hang on, Dr. De Wee. Yeah, we are going to get out of track. Okay. Her question was, why was, you confirmed that a legal opinion or legal opinions were sought, and I think her question was, why were they sought or why was it sought? I think just answer that question if you have an answer for it.
Let me simplify here. There were legal opinions that were obtained.
Yes.
One from state law advisors and another from National Treasury.
Mm.
So there were opinions that were sought.
Mm. Mm.
But the opinions that were sought, remember in the Department of Justice.
But you see, Dr. De Wee, as far as I'm concerned, there is nothing wrong with seeking a legal opinion.
It's fine, let me leave it there. There is
nothing. So to the extent that you may be concerned about anything about seeking a legal opinion. If you are, let's wait for her to get there, because
it's fine,
as I'm concerned, if you need a legal opinion, you must ask for a legal opinion. There's nothing wrong with that.
I'll wait. I'll wait for for Advocate September to guide me.
Yes.
But there was a legal opinion obtained.
Yes. All right, Ms. September.
Dr. De Wee, there were two legal opinions that were sought, one from the Department of Justice Law Enforcement Unit and the other from National Treasury. Please clarify why you sought these legal opinions.
Well, check first whether he is the one who sought. Did you seek one or both opinions, Dr. De Wee?
I think we asked for both.
Yes, okay, all right.
I think we asked for both.
Yeah, what gave rise to the need for the opinions?
Chair.
Yeah.
This is what I was trying to clarify.
Now that's where we've now reached it. You wanted to tell us before we reached it. Now we have reached it.
This is what I wanted to clarify. There were two processes. We in the Department of Justice were very worried about the efficacy of physical security in our operations. Now, by physical security, I mean the guards, the guards with batons. We ask ourselves important questions about the efficacy of relying solely on that. And we came to learn that the security industry has moved to modernize security by using technology. Are you with me? So because of that, and this is why I was stopping Ms. September from jumping to the 600 million. I wanted to inform her that Ms. September, it didn't start with the 600 million. There was a process before. So because we didn't have capacity in the Department of Justice, our capacity was rudimentary, to say the least. We decided to seek to advertise for the service of a consultant who will then assist us to tell us, to advise us on what specifications would be needed to be able to advertise for such a big tender of 600 million. We didn't want to go into this big tender because we didn't trust our knowledge, in my understanding. So the reason we sought a legal opinion, I would like to draw your attention, Chair, to 431. If I can draw your attention to 431.
That is page 431.
Page 431.
Yes.
I would not go into paragraph 412 because paragraph 412 does indicate what documents are not there, and I'm not in a position to explain why they are not there. I think you ventilated your concern earlier in the process.
Yes.
But I would like to take you through paragraph 413 right up to paragraph 419.
Okay.
Okay.
Yes.
Now look at paragraph 413. It says the following, and this is not something written by me. It has been written by forensic investigators appointed by the Director General of Justice, Advocate Madonse. It says the following. We reviewed a copy of an internal memo signed the 23rd of April 2008 by a project manager with the subject pre-qualification for the supply, installation, commissioning and maintenance of a national security infrastructure for the Department of Justice and Constitutional Development, respectively signed and supported by myself. At that time, I was a chairperson of a bid evaluation committee, dated the 24th of April 2008 and approved by the Director General on 26 July 2008. We noted the purpose of the memorandum was to obtain approval from DBAC to proceed to phase one. In other words, to proceed to phase one once a consultant has been approved. But look at 414. It says the following. We noted that in paragraph 2 of the internal memorandum under the heading The heading is mentioned. A bid was issued on 29 February 2008 and closed on 20 March 20. In other words, the market was tested as per provisions of the Public Finance Management Act. 18 bid proposals were received by the Department of Justice and no late bids were registered. C, after the pre-evaluation phase, 2 bidders were disqualified. 1, the following companies were excluded for reasons mentioned. D, 16 bids were evaluated for functionality whereby a minimum threshold of 65% was specified. 4 bidders scored above 50% and the remaining 11 bidders scored less than 50% and only 1 bidder scored 79%, which is higher than the threshold of 65%. Now, once we reach this point and realize 1 bidder has scored this much, we were wondering about it and we were not sure. And I guess that's where the point of obtaining legal opinions came into the picture. Now,
why would the score give rise to the need to seek a legal opinion?
We were just asking whether is it competitive enough? We were just wondering whether we just wanted confidence in ourselves, whether is the right way to proceed.
Well, you have a number of bidders. You have a threshold.
Yes.
They get what they get.
Yes.
The one who gets 79 something gets what they get.
Yes.
Did you have reason to think the scoring might be subject to challenge?
I don't know. I think it. I don't know. There should have been reason why it created some certainty in our mind. But we wanted to make sure that when you go to the DBAC, we are certain that we did the right thing.
Or did this one, was the gap too big between?
We were worried about the gap, I guess. We were worried about the gap. And that's why we went for an opinion.
Okay, all right.
Now, let me take you through paragraph 415.
So that covers at least the need, what gave rise to the first opinion. At least the one.
Absolutely.
Yeah.
It gave rise to both opinions. It gave rise to both opinions, not just one, both.
Okay.
Now, let me take you through so that we are together on this. 415 says, we reviewed a copy of an unsigned internal memo dated 15th April from myself, addressed to the Director Law Enforcement and so on. And the legal opinion obtained says the following in 416. It says, I'm of the view, because we were wondering whether this should be adjusted or what, to give other people a chance. 416 says, I am of the view that it will not be fair and just to change the pre-qualification benchmark at this stage. It will in fact prejudice the bidder who did not qualify and give him grounds to take up issue with us if we change the qualification now.
I'm sorry, where are you reading from now?
416, on page 432.
416, okay.
432, if you go to page 432, paragraph 416.
Yeah, I've got it.
Yeah. You can see there on 3, it says, I'm of the view that it will not be fair and just to change the pre-qualification benchmark at this stage. It will in fact prejudice the bidder who did not qualify and give him grounds to take up issue with us if we change the qualification now. And it further says, I am further of the opinion that it would compromise the process. The tender should either be withdrawn, 1, and the process started afresh. Alternatively, the bidder should be allowed to enter the next phase in respect of pricing. If possible, it would be wise not to let him know at this stage that he's the only bidder. And then we can go to the second opinion, Chair, in paragraph 418.
Yes.
In paragraph 418, and this is the point that Ms. September is trying to make about the opinion from National Treasury, which was also obtained. Basically, the long and short of the opinion, it says, when the bid was advertised with a criterion of 65% pre-qualification benchmark, there might have been potential suppliers who refrained from submitting a bid due to this apparent high qualification score. If at this stage you should approach all bidders who submitted bids with a request to indicate whether they should have any objection to lower the prescribed threshold to 50% with the aim to promote competitive bidding, the potential supplier who did not submit a bid due to the high qualification criteria may claim that the system has become unfair. And the recommendation, therefore, is that the bid should be re-advertised with the June benchmark. Now, faced with these two advices that do not agree, you will see it is recorded that on paragraph 419, Chair, look at paragraph 419. It says, we noted that paragraph 2 of the internal directs DBAC to the responses that the DOJ received from DOJ Law Enforcement Unit and National Treasury. Are you with me, Chair? In other words, this statement says the committee that I chaired, it brought to the attention of the DBAC that there were two opinions. And on the basis of the opinions, it says, however, paragraph 4A of the internal memoranda indicates that the BC decided that the benchmark stayed at 65%. Now, the reason for this decision is because of the opinion we obtained on paragraph 4.16. Can you see that, Chair?
Well, what was the question that those who gave the opinions were asked to answer, and what was their answer?
The question was, we were wanting to wonder whether were we wrong to focus on 65% as opposed to just 50%. I think we were just wondering in our mind.
As the threshold.
As a threshold. But we did not want to do it arbitrarily. We wanted to be guided.
And their responses, did they give the same response? Or
no, it was different responses.
Yeah, tell us about it.
The one response in 416, it gives us options. And the options are saying, if we change the threshold, it would compromise the process.
Yeah.
And then they proceed to give us options. It says the tender should either be withdrawn if we do so, and the process started afresh. Alternatively, the bidder should be allowed to enter the next phase in respect of pricing.
Okay,
are you with me?
One.
Yes, but the other one, it says, hey, if you do that, re-advertise altogether.
Yes.
So it is clear that we follow the one. We followed 416.
Okay, all right.
And that's why 4.19 is phrased as it is. But there is a point I want to make, Chair.
Before you make that point, the opinion dealt with at 4.14. That was, who was that from? Is that the state law advisors?
4.14.
Yeah.
No, the opinions are mainly in 416 and 418. 416 is from state law advisors.
You refer in 4.14E, you say legal opinion was requested from DOJ, Law Enforcement Unit, and National Treasury. Okay.
Yes.
So those are the two people. Why would you ask for a legal opinion from National Treasury? Is it simply because they enforce the procurement?
Yes, because they enforce the procurement issue.
Yeah. So maybe it might not be so much of a legal opinion. It's more of a procurement practitioner opinion.
Maybe. Well, pardon my language. You know my limitations on this matter.
You say, okay, you are the people who are the custodians of procurement practices.
Yes.
So tell us whether if we do it this way, that would accord with acceptable procurement practices.
Yes. And
that's why. And then from the DOJ Law Enforcement Unit, what is that? That is not state attorney, is it?
I think it was state law. I don't think it was state attorneys. I think it was state law advisors within the department.
Well, it would be a legal unit, I would imagine, within the department.
Yes, it was a legal unit within the department.
Okay, all right.
But the point I'm going to this length. I'm going to this length to make this point that I am making. I'm trying to draw your attention to the question that was asked by the investigators of the commission, and I think it's probably the question that informs Advocate September. Can I draw you?
That's why I want you to wait until she gets there.
Okay.
Until she gets to that point. But I'm
All right,
saying,
sure.
if she doesn't get to it, make a note, because you obviously would like to deal with it.
All right.
Ms. September, continue.
Thank you so much, Chair. My point is this, Dr. De Wee, is that if you turn the page over to page 433.
Yes, ma'am.
And this is the forensic report of SNG and Grant Thornton done on
Yes.
the department. You will see that it's recorded that the DOJ did not consider the recommendation as provided by National Treasury, that the tender be re-advertised with a new benchmark. So in line with the two opinions, on the one hand, you had an opinion which said re-advertise, and that's what National Treasury says. On the other hand, you have the DOJ opinion which indicates withdraw and start the process afresh, alternatively go ahead. When you look particularly to the last line under paragraph 4.21 on page 433, it informs that the DBAC minutes does not refer to the recommendation from National Treasury, which is the very recommendation that the tender be re-advertised and not go ahead with the BOSASA company called Sondolo IT. Why was that so? As the chair of the BEC, who made that recommendation to the BAC, that they were not aware of the opinion according to what is stated in this report.
You know, Advocate September, a question that puzzles me from the point of view of the commission is that we have two opinions provided. Clearly, the commission has a preference for one as opposed to the other. I think that's the point, because you want to know why we didn't take into account National Treasury's advice. So clearly, in between the two, we chose one, because you can't implement the two at the same time, right? But also, we were driven by the situation in our courts. The situation in our courts was pretty bad. And later on, I will take you through. In fact, maybe let me take you through. Let me just take you through.
Well, Dr. De Wee, at some point you were on the right track on this question. All you need is, I mean, if there are two opinions, one assumes or one expects that you would have applied your mind to both, and that you would have a reason why you go for the one and not the other.
Thank you, Chair.
The question that Ms. September is asking requires nothing more than simply for you to say, the reason why we preferred this opinion over that other one is the following, or these are our reasons. So it's got nothing to do with the commission preferring one opinion or another. So you simply had two opinions in front of you. If you looked at one and didn't bother about the other one, even though you knew it existed, that would be a cause for concern. But one would expect that you would have looked at both and you would have applied your mind to both. And in choosing one, you would have had certain reasons. So her question is simply seeking to give you a chance to say, here are the reasons why we preferred this one and not this one.
Chair.
So it's not about the commission having any preference.
Thank you, Chair. My apology for that, by the way.
Yeah.
Yeah. Clearly, these opinions were conflicting with one another. We chose one because we were worried about the security in the courts. And there's a full memo here, and I don't want to waste your time, which will give you a picture of the situation that was in our courts at that time. So we had to.
No, you can deal with that. That's important because you are saying one of the reasons is you are saying one of the reasons was the situation at the court. So you can deal with that.
I'm glad you have given me the go ahead. Just give me a moment. I'll draw your attention to that memo so that you see for yourself. Just give me a moment. Can I draw your attention? Yeah. Can I draw your attention to page 541 of our documents?
541.
541.
Yes.
I think at a later stage, if time allows, I'm going to speak at length about this memo. But for now, I want to bring the following to your attention so that you have a picture of the situation in our courts, Chairperson. Can I draw your attention to paragraph 2.1 of this memo?
Well, first of all, tell us who the memo was from and who it was addressed to and what subject it was dealing with and what date we are talking about. Then you can draw my attention to the particular paragraph.
Well, this memo was really about the maintenance issues arising from the implementation of the national security infrastructure that has been installed. And it was a memo from the Chief Directorate, Security and Management to the Director General.
Yes, okay.
So
Continue.
I would like to draw your attention to paragraph 211. You know, yeah, because 2.1.1.
Oh, okay, yeah.
It's still on paragraph 541.
Page 541, yeah. I'm there, 2.1.1.
It says, starting from paragraph 2.1.1, there were a number of complaints from the judiciary, prosecutors, members of the public, and officials based on the number of incidents that were occurring in many of DOJ and CD service points. Some of the incidents include magistrates, judges, prosecutors, lawyers, and interpreters being attacked inside the court premises. These incidents were so bad to such an extent that a prosecutor was stabbed to death in Pretoria Magistrates Court during the day, and in Cape Town, the magistrate was stabbed on the face while presiding over a case. Next page, violent crimes that occurred at service points also involved the attacks of witnesses, staff members, members of the judiciary, and family advocates inside the justice premises. 212, in addition to human-related attacks, there were a lot of burglaries that were occurring as a result. A lot of departmental equipment, furniture, third-party funds, and court records were missing. The courts also became more of drug trafficking zones. 213, these incidents did not only affect the DOJ and CD goals in terms of access to justice for all. They also affected the services of other stakeholders like correctional services, social development, and South African police services. The continued loss of deceased estate files, court records, face value forms for the vote and third-party funds accounts, cash, official stamps for judges and magistrates, state attorney records, etc., indicate that the traditional provision of guarding services alone is not enough and not sustainable to mitigate risks faced by the department. And one could associate these challenges and incidents to a number of influences like socioeconomic factors, increase in crime trends, inherent risks, general nature of the departmental environment, and services being rendered, human error, and other risk exposures. So at least that paints, that gives you a sense of the situation we were faced with, Chair.
Does that speak to agency or what does that speak to?
It speaks to agents.
Okay. So
I mean, if prosecutors are stepped in, magistrates are
yeah, so
there's nothing more urgent.
So are you saying that the one opinion would have entailed a delay?
Yes.
And the other opinion, implementing the other opinion would enable you to address the issues urgently.
That's correct, sir.
Okay, Ms. September.
Now that you've given the reasons why you preferred the one opinion to the other, why did you not, according to the forensic report anyway, why did the bid evaluation committee, or rather why did the bid adjudication committee, not have knowledge of the National Treasury opinion, which called for a re-advertisation?
Again, I would like to draw your attention to a certain document. If you give me a moment, I'll just get it to you in a moment, because I again want to answer the Advocate September in full. Just one moment. I want to draw a certain document to your attention. Chair, can I draw your attention to a document on page 458?
Page 458.
Yes. If you look at page 460, on page 460,
Yes.
you will see that what I'm drawing your attention to is actually the minutes of the DBAC.
Yes.
But I particularly want to draw your attention to page 462 of the minutes.
Yes.
If you look at page 462 of the minutes, on paragraph 7.2 there is bullet 1, 2, 3, 4, 5. Can we see bullet 5?
Yes.
It reads as follows. Since it was one bidder who met the requirements, the department requested advice from the National Treasury and State Law Advice. Are you with me, Chair?
Mm-hmm.
The point I'm making is that the Departmental Bid Evaluation Committee did bring to the attention of the Departmental Bid Adjudication Committee that two opinions were sought. We didn't hide it from them.
Mm-hmm.
So, and remember, and later on, if we have time, I will show you the Departmental Bid Adjudication Committee. And my suspicion really is that these opinions were shared with the Departmental Bid Adjudication Committee, because you can't bring this matter to the attention of the Departmental Bid Adjudication Committee and not share the opinions with the Departmental Bid Education. So at least give us credit. We mentioned it. It was up to the Departmental Bid Adjudication Committee to say, where are the opinions? Can we look at them? Can we address them?
Well,
so the minutes show.
Hang on, Dr. De Wee. The question was whether the existence of the two opinions was brought to the attention of the Bid Adjudication Committee, if I recall correctly.
Yes.
Now, the document we have been reading from, you said those are minutes of, is it minutes of the Bid Adjudication Committee?
It is the minutes of the Departmental Bid Adjudication Committee.
Yeah, so what you are saying is their minutes reveal that they were aware.
Thank you, sir. Thank you, Chair.
Okay, all right. Ms. September?
Thank you, Chair. If I could ask you to turn to page 466, though. It appears that this is a document dated the 10th of June 2008. The purpose of the memorandum is to get the DBAC approval to proceed with the appointment of the recommended bidder. And it's accepted that at page 467, the recommendation promotes the appointment of Sondolo as the service provider for this particular contract, and that the DBAC is to approve to negotiate with the supplier as recorded. For the Director General, that the recommendation memorandum to the Director General be sent direct after the negotiations. And that is, in fact, your signature on page 468. Is that correct?
It is correct, Advocate September, but it is what I'm saying, what I'm agreeing to. I am agreeing to the fact that this is my signature.
Yes.
But I would like to assist the chair and you to say, you remember a moment ago, I have been repeatedly saying to the chair, there are two processes. And my suspicion is that the investigators, given the way they ask their questions, they have probably confused you, because the legal opinion...
Hang on, Dr. De Wee, please don't worry about who is confused, who is not confused. You will be asked questions, just deal with those questions. Don't think ahead of where the question is going. Otherwise, you spend more time than you should. Just answer the questions that she is putting to you.
I apologize.
When we get there, if we get to whatever, where you think there is something, you can deal with it at that stage. And as I said, if when she has finished questioning you, there is something that you think hasn't been covered that you believe is important, I will give you a chance to deal with it. Okay. Yes, Ms. September, was your question answered?
Yes, it's in fact his signature. Thank you so much for confirming that, Dr. De Wee. It's then accepted that the recommendation that was made, despite what you've mentioned earlier, accords with what is stated in the report, in the forensic report. And that is that no mention is made in here in relation to the two differing opinions and the reasons for advancing the one, or adopting the one rather, as opposed to the other, on the face of it. Is that correct?
Well, no mention is made of the legal opinions, because the legal opinions were specifically for the tender to draft specifications. Remember, there was a tender for 2.9 million. In which a consultant was appointed to draft specifications. So the legal opinions that we spoke about earlier were specifically for that. And this is the point I've been straining to bring to your attention. Now, on this one, the legal opinion is not for the 600 million. There was no legal opinion obtained for the 600 million. And it was not mentioned because there was no legal opinion obtained for this. The legal opinion was obtained to appoint the consultant to draft the specifications. I've been straining to make this point.
Yeah, and I guess that the idea was that a legal opinion was required for that, because when the specification is drafted, sometimes that is where the corruption happens.
Yes. Because
then the specification might favor a particular potential bidder. So that, for example, the threshold might be put too high, so that others will just not make it, but only one will make it.
Yeah. So we wanted certainty.
Yeah. Ms. September.
And I then ask you to turn to page 484, please. Paragraph 2.2, sorry, clause 2.2 on page 484, which is the SLA, informs at the third line that towards the end, that the parties agree that negotiations may take place in terms of the change control policy with regards to either the bid price, the number of facilities, or the specifications of the services.
Hang on, Ms. September, hang on. Tell us first that you are still reading on a particular document. This is still the agreement that we dealt with earlier on. Is that right?
Correct, Chair. It's the 601 million service level agreement.
Yeah, okay. And you are reading from what paragraph? 2.2?
Clause 2.2.
Yeah, okay. Continue.
Clause 2.3 identifies certain pilot sites for the project, which are essentially 6 courts. In particular, paragraph 2.3.1 informs, due to the incomplete service specifications in the bid document, the parties have agreed that the contractor will conduct a comprehensive audit at the pilot sites to establish the principal security requirements in general. The parties recognize that this will result in additional costs to both parties, and in this regard, the parties have agreed that the principal will be liable for the costs of any additional equipment that may be required, but that the contractor will forfeit any labor costs relating to the installation of additional equipment. Please explain how this contract, which was initially pegged at 601 million, went out in a tender process when it was anticipated that not to be the conclusive costs to be incurred by our public purse.
Thank you, Ms. September. Again, I would like to answer this question in full with your permission. If you give me a moment,
Okay, just before that, Ms. September, maybe you should have broken up your question. Are you saying that, Ms. September, this is for Ms. September, is your understanding that the price of more than 601 million that was set aside for this project, for this contract, was for more sites than those that are set out in clause 2.3?
No, Chair.
What?
The contract purports to present that the contract value of 601 million was specifically to 127 facilities, but it certainly did not end there. It was anticipated, at least in paragraph 2.3.1, that the specifications that were actually required was beyond that which had been catered for. And so certainly the containment of costs for purposes of procurement is questioned as to what extent it would have been known when this procurement process began, and the deviations which inevitably followed from it, Chair.
Well, I don't understand that. If you said the project, the cost of 601 million and more was for 100 courts to be covered, but the contract talks about less, but the price remained at more than 600 million, I would understand. But you seem to be saying the sites went up beyond what they had been contemplated, and the price remained the same. Is that right?
Maybe let me ask the question differently, Chair.
Yeah, ask them, break the questions up. Dr. De Wee will be able to give you the information.
Thank you. Dr. De Wee, were additional costs incurred over and above that which was contemplated as 601 million?
Advocate September. Again, I would like to address this question in full. because I think it needs a full response.
Yes, but let's find out first. Let's find out first before you go further, because I need to follow. The price that was placed on this project by the department, that was that just over 601 million? Let me start there.
Originally, the 600 million was for 127 courts.
127 courts.
127 courts.
Yes.
But okay. there were delays of about 18 months that happened.
Yes.
And
the quotations that had been given were overtaken by
there were inflationary costs.
The costs had to be adjusted.
Yes, Chair. So when I say I want to respond in full, is because I want to give you a full picture.
Yes,
of how the picture changed in the 18 months.
But you don't need for now to tell me more than what you have told me.
Okay.
You see, when you say initially it was 127 courts, and we're talking about 601 million rand or thereabout, but there was a delay, and the delay pushed the costs high.
Yes.
Even if you don't tell me to how much, already that gives me an answer. You know?
Thank you, Chair.
Thank you. Yeah. Then you wait whether we are asking you about more details about the delay and so on. Okay, all right. Ms. September, continue.
So with the change that was done, with the additional costs that were incurred, were there proper approvals that were obtained for those additional costs, sir?
There's if you look at the SLA, and if, again, I don't want to.
That is the agreement we are talking about.
Yes, if you look at the SLA, let me tell you where the SLA is. The SLA provided for a change control policy.
Yes.
And change control policy provided for variations to be discussed.
Yes.
And if you look at the change control policy, because of all those variations which were prompted by the factors I wanted to take you through, Chair. And because of the delays, it obviously affected the price. Instead of implementing this project in 127 courts, we ended up with 95 courts.
Yeah, in order to stay within the cost.
To stay within the cost. And because of the variations. But the reasons for those variations were in the outline I wanted to give you earlier, but maybe with time you'll allow me.
Yeah. It might not be necessary, it just depends. But you were referring to the agreement. Was there a provision in the agreement that governed delays that could impact on costs? In other words, did the agreement say if there are delays which end up affecting costs, this is how we will deal with that situation?
Yes, the SLA does provide for a change control policy. And in addition, it provides a governance structure so that when there are such delays or difficulties, negotiations between the various stakeholders, in this case, between the principal, which will be the department, the service provider. Remember, we even went so far as appointing the IDT as an implementing agent, as a project manager. So negotiations will take place within that to discuss those variations. And by, let me stop there because you have advised, let me just stop.
Okay. Ms. September?
Dr. De Wee, what was the value of the deviations that were effected to this contract? Do you know?
You know from
Hang on, Dr. De Wee. Ms. September, you were dealing with the escalation of costs that were caused by delays. You are now asking about deviations and costs. Now, deviation in the context of procurement has a certain meaning. Are you talking about the escalation of costs, or are you talking about deviation from procurement processes?
It is understood that there were certain scope deviations which attracted a cost to the department. My question to Dr. De Wee, which he has still not answered, is whether or not the change to the scope and the cost associated with that was properly approved. Since he has not
hang on. Don't be unfair to Dr. De Wee. Yeah, you are combining deviations and other things. If you talk about a broadening or widening of the scope of the work, let's call it that. If you talk about deviations, that's normally understood in the context of procurement to talk about a departure from normal procurement processes. If you talk about escalation of costs, talk about escalation of costs. So when you talked about deviation, where you talk about deviation, as we understand it, from normal procurement processes, or where you talk about something else?
There were two incurrences, Chair, which attracted a cost, according to the report. And perhaps I could take you to page 439.
Yes, but you can tell me without going to the page to say this is what you meant. That's what I want. What did you mean?
Additional costs that were incurred as to be understood, and there were also scope deviations. The scope deviations in particular attracted a substantial amount of money.
Well, what do you mean scope deviation? Broadening of the scope of the project, of the work?
If I could take you quickly then to page 439.
439.
Yes.
Yeah.
Okay, clause 4.5.5.
Yeah.
Second line, we established that the cost of the 32 court buildings where no service were delivered amounts to 177 million. This implies that the actual cost overruns of the additional work performed by Sondolo amounted to 177 million. The DOJ therefore incurred unauthorized expenditure with no approval, as no approval was obtained from DBAC or the DG for the scope deviations, which amounts to 177 million.
Yes, but I want to know, what is your understanding of what this means, the scope deviations?
The scope deviations, as it's understood to be, is that of the initial 127 court buildings, there were 7, for example, that were substituted with other court buildings. In relation to additional costs, there were comprehensive audits that were performed at the 6 pilot projects, which are the 6 courts, 4 magistrate, 2 high courts, at an unknown additional cost to the Department of Justice. My question is then...
No, I don't want your question yet. I just want to make sure I understand what you understand by what they say here, deviations. Are you talking about the adding of work to what had been agreed? Adding more courts, for example? Or are you simply talking about the fact that Court A and Court B were included originally, but they were then excluded, and Court D and Court E were put in their place?
Both, Chair. On the one hand,
let's not call it deviation. It's if you are adding, at least talk about broadening the scope and adding more courts. And if it's replacing one court with another, let's just call it that. They use deviation here. In procurement, deviation has a certain meaning. Okay, so with that understanding, what is your question?
Additional costs of 177 million rand was incurred, Dr. De Wee. Was proper procedures followed to incur this expense?
My understanding, Chair, is that proper procedures were followed, and they were followed in this manner, if I may respond.
Yeah.
Can I draw your attention, Chair, to page 504?
Yes. 504.
504. Now, 504, it established the change control policy.
Yeah.
And as you can see, Schedule 1 of the service level agreement that has been signed.
Yes.
It provides for variations to be dealt with. I don't know if you want me to go through the entire list, but
No,
that's what it does.
not really, yeah. But variations, I take it, refers to all types of variations, including variation of scope.
Absolutely.
Yes, okay.
Absolutely. I also want to bring to your attention paragraph 506. Paragraph 506. No, page 506. My apology, Chair. You know my my English is particularly bad. Sincere apology for that. Page 506. Page 506 is a contract governance structure that has been established by this LA. Can I just quickly read through the functions?
Yeah.
The functions of the steering committee shall be to provide a means for the joint review of issues relating to all day-to-day aspects of the performance of services pursuant to this agreement, to provide a forum for joint strategic discussion and possible variations of this agreement to reflect more efficient performance of this agreement, to provide a means of agreeing change proposals and in certain circumstances pursuant to the dispute resolution procedure to provide a means of resolving disputes or disagreements between the parties. But it will be helpful, Chair, if this memo can be read, just one moment, Chair. It will be useful if it can be looked at as well. It will be useful if it can be looked at against the memo. If I can draw your attention to page 541 of the documents. And this is the point I had wanted to make earlier.
It is 541 of
541, yes. And I would like to draw your attention to 543. If you can go to 543, yes, 543.
Okay.
Now, can we start in paragraph 3.2?
This is once again the memo that was that came from risk management in the Department of Justice and was addressed to the DG via two or more other people.
Yes.
Dealt with
your permission, I really would like.
Hang on one second.
Yeah.
That dealt with the maintenance and support for national security infrastructure in.
That's correct, Chair. That's correct.
Okay.
Yeah.
Yes. Now you can.
I really want to go into at little bit so that we have a picture.
Yeah.
Of what motivated the variations.
Yes. Okay.
And what motivated the change of scopes to the point that instead of doing 127 courts, we ended up with 95, and we end up in a situation where 32 were not done, amounting to the 177 million that Advocate September is talking about. So if you allow, if I may beg your indulgence.
I will allow you, but just so that also whoever is watching or listening can understand. One, originally, the idea was that this project would involve 127 courts.
Correct.
Right? At a certain stage, you had 95 courts.
Yes.
Was that the final number of the courts that ultimately benefited from this project?
That's correct.
That's correct.
Yeah.
So a certain number of courts who originally may have been intended to benefit did not benefit.
32 in particular, yes.
32 in particular.
Yes.
And the prize that had been originally put aside or allocated, or the budget for this project, stayed the same or did not stay the same?
It didn't stay the same.
Yes, it
In
increased.
fact, in fact, there's a portion I'll show you of the forensic audit report where it is recorded what was eventually transferred to the IDT as an implementing agent.
Yes, okay.
From what I saw, it is certainly no longer 600 million because of budget constraints, delays, inflationary costs, and so on.
It ended up being how much, if you are able to say?
It actually ended up being less.
Being less. Okay,
I stand to be corrected, but it was something in the region of 567 million.
That's fine. You see,
instead of 601 million.
It's important to have that framework to say, this is what we ended up with. This is what we had in mind when we started. This is what we ended up with. And then you can come in now to say, this is how we got to that point.
Thank you, Chair.
Okay, go ahead.
Can I proceed?
Yeah.
Thank you. Paragraph 3.2, Chair. On page 543, it states the following. Program and project execution phases, challenges, and other risk contributing factors. Even before the commencement of the project and during the project initiation, implementation and commissioning phases, there were a number of challenges experienced by the department and the appointed service provider, like the signing of the service level agreement, as I indicated earlier, Chair, took more than 18 months due to internal frustrations, as well as limited cooperation from the Department of Public Works and South African Police Services as major stakeholders. After 18 months, the Director General appointed IDT to assist under the same umbrella contract covering other infrastructure projects. There were numerous meetings that were held among all the stakeholders at DPW, South African Police Services, Independent Development Trust, and departmental offices. The intervention of the Director General and Chief Operations Officer was requested, and they also had meetings with them, including correspondence via emails and formal letters. All the meetings were to push for the signing of the service level agreement and the project implementation thereof. All stakeholders, ISM was our ICT unit in the Department of Justice. Facilities was our facilities chief directorate in justice. Security, National Prosecuting Authority, South African Police Services, regional offices, National Department of Public Works and Regional Department of Public Works, the IDT legal team, service provider, and the department's legal counsel and state attorneys were represented in all meetings for the finalization of the service level agreement. After signing the service level agreement, during the approach planning meetings, it was decided to conduct a rapid risk assessment because of the time that has elapsed between the request for proposals, the tender, and the signing of the service level agreement. During the ongoing rapid risk assessments that were conducted, the reassessments for each site project definition report, and the meetings held with the regional heads, judiciary, prosecutors, South African Police Services, Provincial Department of Public Works, Independent Development Trust, and relevant staff members in 2010-2011, the following was discovered, Chair. A, some of the material that was originally specified would no longer suit the building design, either due to new infrastructural changes or tenants installations or DPW projects or aging infrastructure. Judges' chambers, magistrates' secure passages and chambers, doors leading to the benches, server rooms, access to the cash halls, counters in depth trays, bulletproof glasses, protection of record rooms through libraries, prisoners' friend areas, cell areas, interlock offloading areas, consultation rooms, national and provincial control rooms were not adequately covered for effective and efficient security. In some offices and surroundings, new risks have emerged, either due to the establishment of new mines and or population growth in the areas, or new crime trends or new municipal boundaries that led to community protest. There were a number of offices where the building plans could not be supplied by the Department of Public Works or could not be found, as some of them were last seen during the old TBVC states. In other words, many courts did not have building plans, and these building plans have to be done from scratch. There were offices where Department of Public Works had changed focus in terms of REM project or building. My apology, Chair. I just need to take a bit of water. Now I'm saying there were offices where Department of Public Works had changed focus in terms of REM project or building refurbishment project, which should affect security installations. There were offices that were built on rocky areas, which were not initially indicated as such, which would affect the designs and fence tremendously in terms of costs and material thereof. The fire intrusion and detection systems were also not covered adequately to meet the building standards of safety. The department assumed there would be enough space and security for the safety of the equipment to be installed. Some buildings were declared as heritage buildings, and this would require other processes and special applications and material from various heritage councils throughout the country. It was noted during the implementation phase that the heritage councils do not have a standard operating model, which was another twist for the department and the implementing agents, in this case, the Independent Development Trust and Sondolo IT. There were offices, Chair, that took more than 9.5 months to get heritage approvals and had specialized equipment which could not be duplicated or transferred to other courts as they are uniquely designed. The FIFA 2010 offices, and this was a time of preparing for the 2010 World Cup, which South Africa was requested by the international community to host. The FIFA 2010 offices were to be prioritized in terms of basic safety and security infrastructure needs and presidential/ministerial agreements with the international community. The departmental air conditioners were not serviced by the Department of Public Works on time, and this affected the servers and control room equipment. Some of the working air conditioners did not match the specification of the server rooms and control rooms, and some of the departmental doors where security magnetic locks were to be installed were not high security doors to carry magnetic equipment. Now, the point I'm making, if you take these factors and if you take the provisions of the SLA in terms of change control policy and the functions of the structure that was created, you can understand why there were these costs imposed by inflationary constraints, Chair. Thank you, Chair.
But your point is not that the costs went higher than originally contemplated. You say you ended up spending less than had originally been budgeted.
Yes,
and
because
these are some of the reasons.
Yes, Chair.
Yeah, okay.
Yes, Chair.
Mr. Temba?
Yeah. Dr. De Wee, my question is very simple. The additional work, which cost 177 million rand, was that cost approved by the departmental bid adjudication committee or even the Director General for that matter?
Mr. Temba, Mr. De Wee says ultimately the expenditure was 500 and something million, less than over 600 million. Is that something you accept or is that something you don't accept? Because I want to understand, you're saying additional, I want to understand where that comes from, because if you accept what he is saying, I'm not sure that it would be additional. But if you don't accept, then obviously it would be additional.
The forensic report identifies that there was certainly additional work which was not accounted for in the contract value. And that additional cost amounted to 177 million. I can direct you to page 440 at clause 4.61, which informs that there was this additional cost, which read together with clause 4.55, again talks about it as an additional cost.
Yeah, let's take it this way. Cost will be additional if there is more work added to work that had originally been agreed, or there might not be additional work, but the cost might be additional while the work remains the same. Is what you are talking about a situation where there was additional work which fell outside of the original scope that was added, which came with additional costs? Or are we talking about additional costs in relation to the same amount of work?
The former.
The former. Okay. The additional work, was it because courts were added?
There was additional audits that were done, Chair. They were swapping out of certain buildings. So there were certain changes that were made to the contract itself. The contract as contemplated at the time of signing it was for 601 million. That is the amount that went through the process. There was an additional cost incurred of 177 million, which I'm asking Dr. De Wee to clarify as to whether or not that went through another procurement process as such, because it was not contemplated.
I want to understand it first. I want to understand. Let us say the original amount was 601 million.
Yes, Chair.
Okay. If ultimately they used less than 601 million, it can't be additional costs. There can't be additional costs. If, however, what has happened is that they were supposed to spend 601 million on 5 courts, and those courts were A, B, C, D, E. But what has happened is that D and E, courts D and E, fell out, and then they brought in F and G, and it didn't affect the costs. Maybe it wouldn't be an issue, but maybe it would. Which situation of these are we talking about?
It is understood according to the report, Chair, that it's the latter. There's a differentiation that has been made regarding the contract value versus the amount of money that would have in fact been paid.
Yes, but let's leave out the contract value for now. Is it certain courts that were in the list were excluded and new courts were brought in their place? Is that what the report is saying?
There was a certain swapping out. There was also additional work that was done.
Okay, let's talk about this, the change of courts. Is that problematic in terms of procurement?
Chair, could I please?
Okay. You need 5 minutes. Okay, I think Ms. September needs to attend. I think there's something in your eye. Yeah. Okay, let's take 5 minutes adjournment.
Okay. I'm so sorry.
Thank you, Chair.
Okay.
Recording stopped.
We will now resume today's proceedings.
Okay, thank you. Okay, let's continue. Ms. September, I realize that we have gone way beyond the time I allocated.
Recording in progress.
Let me allow you to continue. I propose to give you about 10 minutes to complete. Is that fine?
No, it's not, Chair. There are certainly other aspects that needs to be dealt with in relation to at least one of the other contracts.
Tell me what they are.
The other contract is one which has already been alluded to by the witness, and it relates to the maintenance contract, and particularly his involvement in the reprioritization of funds, which was costed at about 373 million rand in addition to the 601 million rand contract.
No, I'll give you 10 minutes. Anything that you haven't been able to cover, you can send questions to Dr. De Wee, and he can answer by way of an affidavit. So let's try and finish within 10 minutes. Then I will give him, after that, I'll give his attorney, if he wants to re-examine, time to re-examine. And I will give Dr. De Wee time to deal with whatever he has not been able to deal with. In other words, any other questions that you might not be able to cover here orally can be put to him in writing after today, and he can answer by way of an affidavit.
As you wish, Chair. Just to then put the particular issue before the short adjournment to bed, the assertions that have been made are reliant on the forensic report, which informed that we spoke particularly of the 601 million rand by virtue of there being a failure to ensure proper and unbiased specification when it was compiled for advertisement. Additional costs were incurred to the tune of 177 million rand, for which no proper procedures were followed. And that is essentially what the forensic report had informed, which this witness appears to have a different version to.
Yeah, put your questions. As I say, I'm giving you 10 minutes, so put your questions, note questions that you have not been able to put so that you can put them in writing to Dr. De Wee, and he can depose to an affidavit and give answers.
Dr. De Wee, 127 facilities were contracted. Only 95 were complete. Why did Sondolo IT receive full payment for services done?
Chair, with your permission.
Yeah.
Can I draw your attention to page 439? And in page 439, can
yes.
I
just first tell us what the document is, and then proceed to tell us what part of what paragraph we must look at.
The report I'm referring you, Chair, is the forensic audit report commissioned by the Department of Justice. That Advocate September has been referring to.
Oh, okay, yes, okay.
Yes.
Page 439, what
Yes.
paragraph?
If you can focus on paragraph 4.54.
Yes, okay.
Can I read that paragraph for you?
Yes, sure.
We noted from the IDT program project report under item 7, under the subheading notes, the following under paragraph 1, which states Security installation. The IDT has submitted tranches requested for security installation for the overall amount of 601,863,632.22. However, the monies that have been transferred by the Department of Justice and Constitutional Development under, I think NSI stands for National Security Infrastructure Program, is 567,649,108.29. And currently the overall total expenditure is 556,904 and so on. Remember the point I was making earlier, that because of inflationary costs, and for the many reasons that I raised relating to the findings of the rapid risk assessment and so on, ultimately it looks like 600 million was not spent. It was this amount that was spent. It is the forensic auditors themselves saying that.
And so is this amount then the amount as you asserting to be what was paid for the 95 courts as opposed to the 127 originally contracted?
I think that's what the forensic auditors are confirming.
Okay. Can I then quickly, there will be additional...
And again, maybe the point I want to make, again on the 177 million, my understanding is that on the 177 million is the cost of 32 courts. As captured in paragraph 4.55, and maybe, I don't know, I understand that to be an opportunity cost rather than the actual payment. I don't know. And on the question, yeah, let me stop there. I think I've made my point.
Can I ask you to turn to page 605, please?
Yes.
You confirm, sir, that at page 605, it's the bid evaluation and recommendation regarding the 24-hour security guarding and special services for a period of 24 months at various offices within 9 province, which is dated 9 December 2010.
Through you, Chairperson, Advocate September, what page are you referring to?
Page 605.
605, okay. Yes, Advocate September.
And then can I ask you to turn to page 630?
630. 630.
Yes.
Oh, 630, okay.
Are any of these signatures on this page yours?
Advocate, just a moment. I'm trying to get there. I apologize for not being as quick as you are. Yes, the signature on that page is definitely mine, Advocate.
Which signature, sir?
The last one under Acting Director General is definitely mine.
So at this particular date, you were the COO of the Department of Justice, but you were acting as the Director General, and in so doing approved this particular contract.
That's correct, Advocate.
To whom was the contract awarded?
Let me see. Hey.
Maybe to help you, you can turn to page 627.
Yeah, I'll be with you in a moment, Advocate September. 627. Yes, 627. Yes. What is your question, Advocate September?
Name of the company that got the award.
The name of the company that got the there is something wrong here. There's just something definitely wrong. Chairperson. there's a no, Chairperson. If you look on page 626.
626.
Yeah, go to page 626.
Yeah.
Under, you see under paragraph 8, under options available.
Yeah.
You see what has happened there. My former colleagues in the commission, they have blotted out other companies here and left the name of one company.
Yeah.
You can see that. And it gives an impression.
Yeah.
That only BOSASA was awarded the tender.
And that's the purpose of my question.
Let him finish. Let him finish.
Can you see that, Chair?
Yeah.
Now I am saying the blotting out doesn't give the full picture, because you have blocked out other companies. And the point I'm just making, when this tender was awarded, 2010 tender, we operated on the basis of various service providers sharing the contracts in specific provinces. Certainly, if you read the memo, you'll see option 3. Option 3 was where BOSASA was going to be very dominant. If I remember well, it was going to get 7 out of 9 provinces. 1, 2, 3, 4, 5, 6, 7. Yeah, it was going to get 7 out of 9 provinces. But if you option 2 was going to download. So when Advocate September asked me to which company this was given, logically, because other companies have been blotted out, the hope and the aspiration of Advocate is that I will say BOSASA. And I'm saying this is wrong.
No, Dr. De Wee, don't be unfair to Ms. September. And don't be unfair to the investigators, because you give the impression as if they have devious motives for blocking here. I don't think that they had devious motives. You remember earlier on, I was complaining, saying they block even the names of people who were in the evaluation committee with you.
Yes,
and leave your name only.
Yes,
that only your name is not. And I was saying there is no need.
Yes.
You remember me saying that?
Yes, you did say that, yes.
Yes, and I think this is what has happened here too. I think that the thinking must have been something along these lines. Maybe those people have not been given notice. So their names maybe should not be mentioned, and therefore, because this is going to be public, let's block out their names. Now, also here, I suspect that that is the thinking, that, you know, BOSASA is the subject of the investigation, so there's no problem. But maybe these other entities have not been given notice, therefore, let's block their names. You understand? That is what I think. That is what I think.
Yeah.
I don't think it's because they wanted to, they have a motive to say it must look like BOSASA is the only one. But what you are supposed to say when the question is, to whom was that tender given? If it was given to one, you are supposed to say it was given to this entity. If it was given to two, or whatever the number is, because they were supposed to share, you say it was given to this one and another company. You might mention it, you might not mention it, but you say they were sharing. You say the name of the other company is blocked, you know.
Thank you, Chair, for that clarification.
Yeah.
It's just that when Advocate September was raising a question, it didn't come out that way. But,
yes, but you could put it that way. You could say, look, you could say the position is the following. The tender was given to so-and-so, either alone or with so-and-so, but so-and-so's name is not here, or another company they were supposed to share, that name has been blocked, that kind of thing. So Yeah.
Yeah,
Okay.
Chair,
So,
I'm saying the following.
mm,
My recollection of this is that it was not BOSASA alone that was given this tender. If you look at the memo, and I know you spoke about time constraints.
yeah.
If you read the memo, what
Yeah.
happened in this memo was that
Yeah.
there were three options given. In fact, I
Yeah.
remember the DBAC
Yeah.
prevailed over DBEC and
Yeah.
said to the DBEC, hey, don't give us these two options. We don't like them because
Mm,
they represent some kind of monopoly. Let
mm,
us go for three options so that the department can be able to exercise its
mm,
options about what to do. And
mm,
I know that option 3 was particularly not chosen because
mm,
BOSASA was going to be dominant in 7 provinces out of 9. And I
mm.
think the consequence was that the memo recommended option 2. So that, and there are a number of reasons that I can go into them, but I'm
Yeah.
saying certainly it was not BOSASA alone. There was
Yeah.
sharing. If you can allow me, I may find a memo somewhere to in
Yeah.
detail, but that's the point I'm making.
Yes. Okay. No, that's
I
fine.
can find the memo and elaborate on this, but I'm
Yeah.
guided by your time.
No, that's fine. But well, if Miss September says no, but the position is that what the answer you gave is not correct, then we can go to the memo.
No,
But
sure.
if
I'm happy to.
there's
Yeah.
no issues with the fact, your evidence that there was sharing, then there might not be a need. But what you must feel free to do after today, if you want to, is to, through your lawyers, send in any document that can direct attention to any documents in this file which make or support points that you think should be highlighted.
Thank you, Chair.
Yeah. Okay. Ms. September?
Just to contextualize your answer then, Dr. De Wee, your recommendation was off the back of other recommendations of, be it the bid evaluation committee, the bid adjudication committee, and the CFO. Is that correct?
That's correct, Advocate September.
And the option that was then elected was not focused solely for the benefit of BOSASA, but for BOSASA and other companies as spread along option 2 as indicated in this document. Is that right?
That is very important. If through you, Chair, can I say something?
Yeah.
This was very important because what I particularly like about this memo, it counters the narrative that BOSASA was privileged in the Department of Justice and everything was biased towards BOSASA. But this particular memo, in fact, if you read option 3 as opposed to option 2, you can see actually it disadvantages BOSASA. It says, hey, we are going to share. We want to manage our risks as a department. So let there be sharing. And the narrative would make sense if we could have approved option 3. You see, it will be consistent with the narrative created by Mr. Agrees and so on to say we all favored BOSASA. But in this particular case, BOSASA in fact was not favored. Option 2 was basically to share with all other people, which has been the direction in which the Department of Justice and Constitutional Development has been moving towards, to say, let us move away from monopolies. Let us make sure that we give as many service providers as possible an opportunity. Thank you, Chair.
So let's move in the direction of page 386.
I give you only 5 minutes more from now on, Ms. September.
Chair, 386.
Yes. You will note that this is a document which is titled Budget Briefing by Department of Justice and Constitutional Development.
Sorry, I'm lost. I'm lost. You say three what? 326.
No, 386.
386.
Yes.
Okay, just give me a moment. Yes, I'm there.
Okay. Do you confirm that you attended this meeting?
Yes. I think
What meeting this is and so on. Deal with that, Ms. September, so that we all understand what meeting it is, what it was supposed to deal with, and then you can talk about who attended.
Thank you, Chair. So at page 386 appears a meeting note, which is from the Parliamentary Monitoring Group titled Budget Vote, briefing that by Department of Justice and Constitutional Development. It particularly dealt with the department's 2011 to 2016 strategic plan and budget briefing, at which the Director General was present in addition to others, including Dr. De Wee. And there's various discussions that take place at this meeting. If I can ask you to turn to page 391, please. Paragraph 6. I will read for the benefit of the record. It informs Ms. Smuts asked the department to respond to city press.
I'm sorry, you initially said 386. Have you moved to another page?
Yes, Chair. The page I'm referring to now is 391.
Okay, all right, continue.
At paragraph 6, it reads, Ms. Smuts asked the department to respond to city press and report media reports that the department had given a contract to BOSASA in December 2010 to the value of 391 million over 24 months, and another for 333 million related to court security, particularly in view of the statement that the SANDF might now be asked to assist in securing courts. He pointed out that BOSASA was being investigated by the SIU, being the Special Investigating Unit, following allegations of corruption in the awarding of Department of Correctional Services tenders to this company. This matter was apparently now with the NPA. She asked why the department appearing to be awarding contracts to the same company. If I can ask you to turn over to page 392 at the second paragraph, it records, Dr. Khotso De Wee, Chief Operations Officer, DOJ and CD, answered questions around the BOSASA tenders and said that this was recently of concern to the department as well. The contract followed the normal processes of tender advertising, establishment of the bid evaluation committee, who then made recommendations to the bid adjudication committee and selecting a final bidder out of 3 recommendations. The department at one stage had considered cancelling the contract. However, it did not do so because this company was not blacklisted, none of its directors had been charged, and a number of departments had either renewed or awarded contracts to BOSASA. The department thus continued with the contract. It is therefore correct that based on this recordal, that as at March 2011, you were well informed that BOSASA was under investigation by the SIU for allegations relating to tender corruption and that the matter was with the NPA. Do you confirm that?
Well, yes, the record suggests so, Chair.
Okay, then can I ask you to please turn to page 485. I think just.
Is that connected with paragraph, Ms. September, or not connected?
Sorry?
Is your next question connected with this paragraph or not connected?
It's connected with the next tender, which followed this particular date.
Okay, all right. Well, yeah, what is the page?
In the spirit of time.
Yeah, what is the page? Yeah. What is the page number that you gave us?
I'm just double checking something quickly. At page 485.
Yes.
Actually,
Yeah.
Actually, Chair, absent more time, I think let's go then to page 541 instead.
541. Yeah.
This is a document that the witness actually referred to earlier, but it relates to a subsequent tender. The document is dated an internal memorandum dated 8 February 2015. It's sent to the Director General from the CFO, and the subject title is Request for Funding for Service, Maintenance and Support for National Security Infrastructure in 95 offices, the National Control Room, and Summary of Business Case. Dr. De Wee, is it correct that this maintenance contract related to the 601 million tender that we spoke of this morning?
Yes, that's correct.
Okay. And is it correct that there was a query in relation to whether the original contract included or excluded maintenance for which this contract concerned?
Yes, I think the then Director General wanted clarification on that.
Yes. And if I could then take you.
Chair, can I just say something with your permission?
Yeah.
You know, there was a question that was raised earlier on the parliamentary question by the Honorable Ms. Dean Smarts.
Yeah.
I'm just worried that I might forget.
Yeah.
Is it not? Can I, with your permission, just respond to that?
Yeah.
So that as we move to other areas, at least I would have exhausted.
Yeah, no, that's fine, because I also have a question arising out of that, but start.
Yeah. I indicated in the response when I was in Parliament already that as far as we are concerned, proper processes have been followed. And I can take you through the memo if your time permits to show what processes were followed. And by processes, I basically mean there was a proper advertisement. The BEC looked at it. The bid adjudication looked at it, and after that, the CFO recommended it via the Office of Deputy Director General Corporate Services, and then it came to the Office of the DG, where I was acting at the time, and I looked at the various options. I applied my mind, and I thought it made sense, and I approved. So basically that. But I want to draw your attention to page 412.
Is that connected with this? Because
it is connected with
412.
Yes.
Okay, all right.
In 412, below paragraph C, I'm basically making a point that I do not recall the SIU report being shared with me, and consequently I have not read it. But I'm making the point that the department simply advised and insisted that relevant prescripts such as the PFMA and relevant treasury regulations must be followed in the department's procurement processes. In this regard, the National Treasury Guidelines of 2004, titled Supply Chain Management, a Guide for Accounting Officers and Authorities, provides, amongst others, in paragraph 253 that in dealing with suppliers and potential suppliers, institutions should preserve the highest standards of honesty, integrity, impartiality, and objectivity. Be fair, efficient, firm, and courteous. Achieve the highest professional standards in the awarding of contracts so as to maximize value for money while adhering to international standards. Provide clear specifications for requirements which encourage innovation and refer, where appropriate, to relevant technical and other standards. Make available as much information as suppliers need to respond to the bidding process and to define and publicize procurement contact points. Manage the bidding process so that genuine competition is preserved and discrimination is avoided. Make available the broad criteria intended for the evaluation of bids, to evaluate bids objectively and to notify the outcome promptly. within the bounds of commercial confidentiality to debrief unsuccessful bidders of the outcome of the bidding process so as to facilitate better performance on future occasions, achieve the highest professional standards in the management of contracts, pay promptly for work done in accordance to standards as set by a legal and binding contract, and respond promptly, courteously, and efficiently to suggestions, enquiries, and complaints. I'm saying this is a Treasury guideline on how to deal with this matter, in addition to the public finance management and its regulations. And I was saying, if the above mentioned contracts were blocked on the basis of the SIU report and hearsay alone, without any substantial evidence, there's a risk the above provisions pertaining to impartiality, objectivity, fairness, genuine competition, and avoidance of discrimination were likely to be violated. Thank you, Chair.
Well, it connects with my question, which I have raised at different hearings when we have dealt with, the Commission has dealt with BOSASA. The evidence that the Commission has had suggests that BOSASA began to have all kinds of allegations of corruption involving it and the government departments or government entities, particularly the Department of Correctional Services, long before 2010. It was in the media. It continued to be in the media. But it continued to get government contracts. And I've been asking the question, how was it possible that an entity that was known to have all kinds of serious allegations of corruption against it, how was it possible that for so long, so many years, even with those allegations, it continued to get contracts after contracts from government departments? Now, you were in a leadership position within the department. You were COO. And the issue that was raised by Ms. Matz that we are dealing with raises this question in a way. Why did the department continue to give contracts to an entity that is publicly associated, was publicly associated with serious allegations of corruption?
Do you want me to respond, Chair?
Yes.
Chair, I think I share your concern, and your concern is well placed. But responding for myself, and only for myself in this case, because I don't have a mandate to respond on behalf of all other people or even the state. I'm saying if we knew then what we know now, a different set of considerations were going to be made. But at that time, what we know now was not as clear as it is now. And for me as a COO, I was very concerned that we should not prejudice people merely on the basis of media perceptions, because quite frankly, Chair, the media can also get it wrong.
No, the media can get it wrong, but the media can get it right too.
Yes,
I agree.
Yes.
And in case the media is right, and you continue to give contracts and tenders to this entity, can you see what would ultimately happen? Which is what I think has been revealed. I mean, there is, on the evidence that has been placed before the commission, there is absolutely no doubt that BOSASA was involved in grand corruption. It was involved in corruption of another level. It had no it had no qualms about using a lot of money to bribe government officials. It also, on the evidence before the commission, bribed officials in the private sector when it was dealing a lot with the private sector in the early 2000s or thereabout, or late 90s, when it may have been known by another name then, but the same entity. There is absolutely no doubt. I mean, you are aware, we were shown during Mr. Agrizi's evidence, we were shown even cash. I mean, we might not be, there might only be a few government officials in respect of whom the evidence is direct that has been placed before the commission. But there is no doubt that there are many for whom provision was made for bribes. We just don't have the evidence that they received it. But if you look at the evidence given by Mr. Agrizi and other BOSASA officials, you can see how much was being put aside just for bribes. You know, there might just not be evidence whether the people who were supposed to deliver the money to the people who have been mentioned, whether they actually delivered the money all the time or at all, we don't know. But it was involved in a lot of corruption. That is BOSASA. And one asked the question, but when all of these allegations were in the media, shouldn't this have been of concern to government officials? Shouldn't they have said, but you know what, really, what if these allegations are true? So that is of concern. And of course, looking at where we are, another question is that should concern the commission is, what is it that should be put in place to make sure that what BOSASA did doesn't get repeated by any other company in the future? And of course, that government officials are not going to be able to keep on giving contracts to companies that face serious allegations of corruption. So, but I put this question to you because you were senior and you were dealing with these matters to try and understand what was the situation. Now, you have said, I think, if you knew then what you know now, you may have dealt with the matter differently. That's just your answer and not the answer for other people. But were these concerns, were these issues discussed within, for example, the Department of Justice? The concerns about BOSASA continuing to get contracts from the Department of Justice in circumstances where there were these allegations against it?
Chair, there were concerns, but the difficulty that all of us were confronted with was that we did not have a clear legal basis to act on this matter. And like I say, if we knew then what we know now, I'm sure a different set of considerations would have been made, because we share your concern.
Yeah, well, at a certain level, one might say, okay, maybe one should have some understanding up to a certain point about that. But if you were an official given the power to appoint people to the department, if you are faced with an applicant for a job who had no serious allegations of corruption against him or her, and you had another applicant for the same job who had serious allegations of corruption, would you say it doesn't matter?
I wouldn't say so, Chair.
Yeah, you would not say
so. No, I wouldn't say so.
Yeah.
But it will again depend on the substance of the allegation, because one would also want to be careful that some people can be very malicious and destroy other people's image without any substance and without any base.
No, I understand that completely. But what I'm thinking is that you would not appoint the person who has serious allegations of corruption over their head, even if they were just in the media, when they are competing with somebody for the same job who has no such allegations. Why was it different with a bid for a tender with regard to BOSASA?
Can I respond, Chair?
Yes, please do.
My view is that this is a question for reflection from all of us. And this is where we hope that your report will guide us on this matter. Because I would imagine we have all learned our lessons. We have all, and that's where the importance of this commission has always been to me, because this commission is going to give a response to serious questions that have been of public concern for many, many years. And I can only say that I'm sure my colleagues in the public service are looking forward to the report so that they can get guidance on how to deal with such matters.
Well, I don't want us to stay too long on the matter, but I simply would have thought that faced with that kind of situation, one wouldn't wait for a report. Here is this entity, it keeps on wanting contracts, it sends bids, okay, it is entitled to send bids, but we are not obliged to give it work when it has got these serious allegations of corruption in the public domain about it, when there are others who have no such allegations hanging over them. But I guess that you have made the point you wanted to make.
Thank you, Chair.
Okay, all right. Mr. September, I think we have run way out of time. Do you have one or two questions to wrap up?
Yes, Chair, I thought my clock stopped when the discussion was being had.
Well, let us take it as having stopped. But I give you the chance that you can send questions to Dr. De Wee to cover any other issues that you haven't covered. I ask you, Dr. De Wee, and your legal representative to respond to such questions by way of Dr. De Wee deposing to an affidavit. And in addition, I give Dr. De Wee an opportunity to say if there are any other issues that he wishes to deal with by way of a written document, or highlight any parts of this file, this bundle, that he would like to highlight, he must feel free to do so. But having said that, I do want to give you an opportunity to re-examine if you wish to, but if you have no re-examination, then there is no problem.
Might I be permitted to just ask 2 or 3 questions off the back of what Chair has placed on record now?
Yes, yeah.
Agreement that we were dealing with.
Yeah, you want to ask
Just
questions for clarification?
Just very quickly, Chair. But
Yeah.
it links to what Chair has raised. And so
I guess you want to ask me, not the witness.
No, the witness.
No, I don't want you to ask the witness. Put that in your written questions. Include that in your written questions. I want to give Mr. Matime the opportunity to re-examine Dr. De Wee if he wishes to re-examine. If he doesn't wish to re-examine, they would be free to clarify anything they wish to clarify in a supplementary affidavit. Would you like to re-examine, Mr. Matime?
Person, thank you. I think there are two aspects. One
Yes.
on maintenance, and the other one on the status and the extent of authority of IDT in the whole process when it was appointed by the department. And I think those issues we can put it in writing, because I didn't hear them, put in such a way that Yes, the question of maintenance and the question of IDT. Those are the two aspects that I would have thought that I would re-examine on, but we can put it in the
affidavit. Yeah. Okay, no, that's fine. So any issues that you would have liked to re-examine on, you can clarify in an affidavit that can be sent through. I will ask that any affidavit or affidavits that can be put through should be with the commission not later than the 10th of August. Yeah. Yes. And to the extent that, Ms. September, you will want to put questions to Dr. De Wee, other questions that you would like him to deal with in written form, you must send them those questions not later than this coming Monday.
Chair, I really only have 2 questions.
That's fine, but do it in writing. Do it in writing. Okay, thank you very much, everybody. We are going to stop now. We have taken much more than I had intended we should take. Thank you very much, Mr. Matime. Thank you very much, Dr. De Wee. Oh, Dr. De Wee, I had promised you that when we come to the end, I will still give you some chance to deal with whatever you might think was not emphasized. Of course, I've said that can be done in writing, but there may be some important issues that you would like to deal with. And I can give you some time, maybe 5 minutes, if you want to deal with anything that you think is quite important for you to deal with that hasn't been covered.
No, Chair, I'm happy with your ruling. I would like to abide by your ruling.
Oh, okay.
Thank you,
No,
Chair.
that's fine.
Yeah.
Okay, that's fine. And thank you, Ms. September. Thank you very much. Thank you. We are going to adjourn then for the day. Thank you to everybody. We adjourn.
Thank you, Chair.
Thank you, sir.